जय हिंद दोस्तों। टुडे वी डिस्कस द प्रीवियस ईयर क्वेश्चंस ऑफ ऑल इंडिया बार एग्जामिनेशन which is very helpful for your upcoming all India bar examination 20 AIB 20. So before we discuss the previous year question, I would like to share one interesting case story before you, which is totally based on all India bar examination. तो हाल ही का ये इंसिडेंस है, ये केस आया था गुजरात हाई कोर्ट में, जिसमें जो पिटिशनर होते हैं वो अपने जो ऑल इंडिया बार एग्जाम के रिजल्ट को चैलेंज करते हैं, जिसमें ऑल इंडिया बार के एग्जाम में वो फेल हो चुके थे। तो उसने अपने रिजल्ट को चैलेंज किया था गुजरात हाई कोर्ट में। तो गुजरात हाई कोर्ट ने स्ट्रिक्ट नोटिस इशू किया इसमें बार काउंसिल ऑफ इंडिया को, और ये कहते हुए कहा कि जो ऑल इंडिया बार एग्जामिनेशन में जो स्टूडेंट फेल हुआ है, जिसने ये पिटिशन डाला है, वो एलएलएम होल्डर है, एलएलएम क्वालिफाइड है, वो भी फर्स्ट डिवीजन से, जो कि क्रिमिनल स्पेशलाइजेशन जो है उसका क्रिमिनल क्रिमिनल में है। उसके बावजूद एलएलबी भी फर्स्ट डिवीजन से पास है, उसके बावजूद भी आप जो एआईबी का एग्जाम है उसको क्वालिफाई नहीं कर पाते हैं, जो कि एक मिनिमम क्राइटेरिया रखा गया है आपको एडवोकेट बनने के लिए, कि जो जिसमें कि 100 क्वेश्चन पूछे जाते हैं, जिसमें 100 में आपका जो क्वालिफिकेशन है वो ओनली 50% आपको इसमें लाना होता है। 50% आप के बाद आप क्वालिफाई हो जाते हैं, इसमें आपका नंबर नहीं आता है, सिर्फ आप पास या फेल होते हैं इसमें। तो आपको एकदम मिनिमम 50% लाना होता है, और अगर आप कैटेगरी से बिलोंग करते हैं तो 45% है आपका उसका कैटेगरी क्राइटेरिया पास होने का। और 100 मार्क्स का क्वेश्चन होते हैं, टोटल 100 क्वेश्चन होते हैं, जिसमें निगेटिव मार्किंग भी नहीं होता है। और एक बेसिक पैरामीटर है आपको, मतलब आप अगर एलएलबी कंप्लीट कर लिए हैं और आप एडवोकेट बनने जा रहे हैं, तो उसके एग्जाम क्वालिफाई करने के लिए, जिसमें बेसिक क्वेश्चंस होते हैं। और जो कोर्ट का कमेंट था इसमें कि ये मतलब कि सिलेबस ऐसा है और पैटर्न कुछ मतलब कि एग्जाम का ऐसा है कि ओपन बुक सिस्टम है एग्जाम, उसके बावजूद भी आप इसमें पास नहीं हो पा रहे हैं, और उसके बाद भी आप ग्रेस मार्क्स के लिए, उस जो पिटिशनर था उसमें वो कहा गया था कि फेल हो चुके हैं, जिसमें कुछ क्वेश्चन को विड्रॉल कर लिए गए हैं, तो ग्रेस मार्क्स मुझे दिया जाए, या ग्रेस मार्क्स कुछ कम होने के कारण वो क्वालिफाई नहीं कर पाई थी, शायद 50% भी मार्क्स उसमें ऑब्टेन नहीं कर पाई थी वो, तो जिस कारण वो ग्रेस मार्क के लिए तो एकदम स्ट्रिक्ट मतलब कि टिप्पणी करते हुए गुजरात हाई कोर्ट ने कहा। और ये हाल ही रिसेंट है, और इसी दिसंबर एआईबी का जो एग्जाम हुआ था एआई 19, उसमें वो स्टूडेंट अपेयर हुआ था, जिसमें वो फेल हो गया था। तो ये जो एग्जाम है बहुत जरूरी है क्वालिफाई करना, किसी को भी अगर एडवोकेट बनने जा रहे हैं उन लोगों के लिए। तो ये मैं केस इसलिए बताया हूँ, इससे डराने का मुझे कोई भी ये मतलब इंटेंशन नहीं था, बस ये बताना था कि एक एलएलएम होल्डर होने के बावजूद भी अगर एआईबी क्वालिफाई नहीं कर पाता है तो किस तरह का लॉ पढ़ा जा रहा है, या किस तरह से लोग पढ़ रहे हैं, इस पे सवाल खड़ा होता है। तो इससे अच्छा है कि जो आप जो अगर आप लॉ कर रहे हैं तो कम से कम जो बुक्स हैं उसको अच्छे से रीड किया जाए। उसके बाद ओपन बुक सिस्टम वो है, इसमें आप बुक बेयर एक्ट को अच्छे से पढ़ के जाएं। आपको टाइम कितना टाइम पीरियड में, जैसे कि अगर आपको जो टाइम पीरियड मिलता है उसमें क्वेश्चन सॉल्व करने के लिए, उस टाइम पीरियड के अंदर आप कैसे क्वेश्चन को सॉल्व कर ले, कैसे क्वेश्चन को ढूंढे अपने बुक से, उसका टाइम पीरियड, क्योंकि आपके पास आपको क्वेश्चन सारे आते होंगे, बट इसमें होता क्या है कि क्वेश्चन आपके ढूंढने के चक्कर में बुक से वो काफी क्वेश्चन छूट जाते हैं बच्चों के। तो इस पे ध्यान रखना है कि कैसे क्वेश्चंस को हम ढूंढे, अगर नहीं मिल पा रहा है तो कैसे मैं ऑप्शन से उसको पिक करूँ, कि ऑप्शन खोज के निकालूं बुक से कि इस ऑप्शन में ये आंसर फॉल कर रहा है या नहीं कर रहा है, इस तरह से कैसे चूज करूँ आंसर, सही करेक्ट आंसर को टिक लगाऊं, इस पे ध्यान देने की जरूरत है। तो ये हाल ही रिसेंट है, आप जाके इसको गूगल से भी पढ़ सकते हैं। ये गुजरात हाई कोर्ट का इसमें बार काउंसिल ऑफ इंडिया को नोटिस इशू हुआ था इस केस में। तो हम आगे ऑल इंडिया बार एग्जामिनेशन का प्रीवियस ईयर का क्वेश्चन को हम आज देखते हैं, और इसके बाद भी इसमें हो सकता है अगर अच्छा रिस्पॉन्स आया तो मैं सीरीज लेके आऊँगा इसके लिए, और आपका बेस्ट प्रिपरेशन हो सके ऑल इंडिया बार एग्जामिनेशन का, विदाउट एनी गाइडेंस, विदाउट एनी बुक, प्रीवियस ईयर क्वेश्चन को पढ़ के, देख के, समझ के, आपका अगर नॉलेज बढ़ता है इस चीज़ में, जो कि काफ़ी हेल्पफुल होगा, तो इस पे आप ध्यान दें। सो हम डिस्कस करते हैं, डिस्कस प्रीवियस ईयर क्वेश्चंस। So we start from question number 1. In which case was registered society held to be an authority for the purpose of Article 12? So the answer is Ajay Hasia versus Khalid Muzib. Second question. In which case did the Supreme Court of India held that fundamental right cannot be waived? So the answer is Baheshwar Nath versus IT Commissioner. Then after third question. By which constitutional amendment was clause 4B inserted into Article 16? 81th constitutional amendment 81, फोर्थ विड्रॉल कर लिया गया था, फिफ्थ भी विड्रॉल कर लिया गया था क्वेश्चंस को. देन आफ्टर सिक्स्थ पे, the reports of the Comptroller and Auditor General of India relating to the account of a state shall be submitted to the governor. Seventh, which of the following article of the Constitution of India declared that the Supreme Court shall be a court of record? Article 129. 8. Which article deals with the power, privilege, and immunity of Parliament and its member? So the answer is 105. Article 105. Which constitutional amendment act inserted provision related to GST? 101 amendment. Who can initiate impeachment proceeding against the President of India? So either House of the Parliament. Then after 11th, Bharatiya Nyaya Sanhita 2023 considered force to be criminal force. Answer is when it is used intentionally without consent, causing injury, fear, or annoyance. 12th. According to Bharatiya Nyaya Sanhita 2023, what is the maximum fine for making for us a document that resembles a currency note or a bank note under section 182 clause 1? 300 rupees. 13. According to the provision of the Bharatiya Nyaya Sanhita 2023, the right of private defense of property extend to the voluntary causing of death or of any other harm to the wrongdoer in which of the offense committed or attempting to be committed. So the answer is 1 and 2 both. The answer is 1 and 2 both, means robbery and housebreaking after sunset. Both दोनों होगा. 14th withdrawal कर लिया गया था. 15th, Amit attending to 15th. Amit attending to cause the death of Vijay attack him with a knife. Vijay sustained a severe injury and dies on the spot. The investigation revealed that Amit acted with knowledge and his action were likely to cause death. However, there is no evidence of premeditation or intent to murder. Vijay, culpable homicide not amounting to murder under section 304 of IPC. The answer is option number B. Then after 16, Amit and Rani decide to break into a house at night with the intent of stealing valuables. They use a crowbar to force open the door, but before they can take anything, the owner of the house, Vikram, unexpectedly arrives home. Amit and Rani panic and run away without stealing anything. The police arrest them the following morning based on a complaint from Vikram. Which of the following offense under BNS have Amit and Rani committed? House trespass with intent to commit theft. Option number B. Then after 16, 17. A punishment for rape in cases where the victim is a woman below the age of 16 or 20 is included in which section of the BNS? The answer is 65. Option number B. Section 65. 18. Question number 18. A new offense of snatching has been introduced by the BNS. Which section of the BNS define snatching as an offense? So the answer is 304. The section 304 talks about snatching. Question number 19. Consider the following statement and answer the questions given below. Mr. Patel, being a police officer, received a complaint and information that Raju was involved in a robbery of bank and also helped to hide the valuable property in his farm. As stated by two villagers, with this regard, consider the following. The police officer, Mr. Patel, may arrest Raju without warrant when the answer is second and fourth both. Means and option number B. क्या कह रहा है सेकंड since the reasonable complaint against Raju has been received and there is strong suspicion exists due to the testimony of villager, he can be immediately arrested. And the fourth option, Raju can be arrested so as to prevent him from making any inducement, threat, or promise to any person acquainted with facts and circumstances. So the option is the question number 20. BNSS, Bharatiya Nagrik Suraksha Sanhita, introduced the provision of registration of FIR relating to commission of cognizable offence irrespective of area where the offence is committed. FIR is known as zero FIR. The option is B. Then after come on to question number 21. 21. The BNSS mandate a forensic team to visit the crime scenes to collect evidence for offence punishable with imprisonment for at least क्वेश्चन नंबर 21 ऑप्शन इज सी 7। कम से कम 7 साल का सजा होना चाहिए फॉर एटलीस्ट 7 ईयर। देन आफ्टर क्वेश्चन नंबर 22, which section of BNSS allow for trial in absentia of proclaimed offender? So the answer is 356 section 356 356। Question number 23, which section BNSS facilitates trial and proceeding to be held in electronic mode? Section 530। Which section BNSS repeal the Code of Criminal Procedure 1973? So the answer is 531। Section 531 section of BNSS repeals the Code of Criminal Procedure 1973। क्वेश्चन नंबर जो 25 है उसको विड्रॉल कर लिया गया था। 26 पे आते हैं। क्वेश्चन नंबर 26, which section of BNSS mandate the appointment of a designated police officer in each district and police station to provide information about arrest individual to the general public? Option is C, section 37। 26 का C 37, सेक्शन 37 जो मैंडेट करता है अपॉइंटमेंट ऑफ अ डेजिग्नेटेड पुलिस ऑफिसर इन ईच डिस्ट्रिक्ट और पुलिस स्टेशन टू प्रोवाइड इन्फॉर्मेशन अरेस्ट। अब जो जिनको भी अरेस्ट किए हैं उनका अब जो मतलब मैंडेट द अपॉइंटमेंट ऑफ अ डेजिग्नेटेड पुलिस ऑफिसर इन ईच डिस्ट्रिक्ट एंड पुलिस स्टेशन प्रोवाइड इन्फॉर्मेशन प्रोवाइड करना हर इंडिविजुअल को पुलिस स्टेशन में। देन आफ्टर क्वेश्चन नंबर 27, which section of BNSS introduced provision for identifying, attaching and forfeiting the property of proclaimed offender located outside India? So option is D, section 86 है। Then after which section of BNSS places restriction on the adjournment of trial ensuring the expeditious resolution of cases? Answer is 346। The section is 346। तो काफी BNSS से क्वेश्चन पूछे गए हैं। Then after question number 21, a suit is pending in a district court A, but one of the parties, Mira, requested it transferred district court B, claiming that the judge in court A is biased. The opposing party, Ravi, object stating that the request is baseless. Who has the authority to decide whether the suit can be transferred? The answer is B, the High Court or the Supreme Court. Then after 30, Maya files a suit in court A for the recovery of some money from her neighbor Neha. During the proceeding, Neha requests that a third party Seema be added to the suit. As Seema is allegedly liable for the debt, Maya objects, claiming that Seema is not necessary party. Court A then review the application and decide that Seema should indeed be included as a defendant. Which principle of the CPC is applied in the situation? So the answer is Order 1, Rule 10, joinder and substitution of the parties. Option question number 31, which section of the CPC allow for appeal from original degree? Which section of CPC allows for appeal from original degree? Section 96। 31 का A, section 96। 32, under CPC what is the maximum time needed for filing a written statement in a suit? So the answer is 90 days maximum time period for writing for filing a WS. Then question number 33, which section of the CPC provide exemption of the President of India and the Governor of State from personal appearance in the court? So the answer is section 133। 133 जो कि एग्जेम्प्ट करता है प्रेसिडेंट ऑफ इंडिया और गवर्नर को पर्सनल अपीयरेंस कोड के लिए। देन आफ्टर क्वेश्चन नंबर 34, व्हाट इज द टर्म यूज्ड फॉर कोर्ट पावर टू ट्रांसफर अ केस फ्रॉम वन कोर्ट टू अनदर अंडर द कोड ऑफ सिविल प्रोसीजर? ट्रांसफर ऑफ सूट। 34 का डी, ट्रांसफर ऑफ सूट्स। 35, which under which order of the CPC the procedure for summary suit is provided? summary suit का जो order है वो 35 का आपका हो गया B, order 37। ऑर्डर 37 में समरी सूट के बारे में बात किया गया है। इसमें 10 दिन के अंदर आपको अपना अपीयरेंस मार्क कराना पड़ता है, बहुत चीजें रहती है समरी सूट में। Then after question number 36, which section of CPC deals with the principle of res judicata? So the answer is section 11, it talks about the principle of res judicata. Section 37, dash of the CPC provide for an interpleader suit है, तो सेक्शन 88 जो कि बात करता है इंटरप्लेटर सूट के बारे में। सो 38 पे हम आ गए, विच सेक्शन ऑफ द CPC प्रोवाइड फॉर द पेमेंट ऑफ कॉम्पेंसेटरी कॉस्ट? CPC जो बात करता है पेमेंट ऑफ कॉम्पेंसेटरी कॉस्ट। सो द आंसर इज सेक्शन 35 क्लॉज ए, सेक्शन 35 क्लॉज ए। 39, which word is inserted in section 22 of the BSA that was not present in section 24 of the Evidence Act? जो कि जो इंसर्ट किया गया भारतीय साक्ष्य अधिनियम में, जो कि 24 एविडेंस एक्ट में नहीं था, वो कौन सा वर्ड है? सो द आंसर इज coercion. So the answer is coercion, जो पहले नहीं था. Existence of course of business when relevant is discussed in existence of course of business when relevant is discussed in section 14 of the BSA 2023. Question number 41. In criminal trial, Rajesh is accused of theft. During the investigation, the police recovered a stolen laptop from a location known to be frequented by Rajesh. His fingerprints are found on the laptop. According to the Bharatiya Sakshya Adhiniyam 2023, how should be the court interpret the piece of evidence? So the answer is the recovered laptop and fingerprint are circumstantial evidence that can be considered along with other evidence, but do not by themselves prove guilty beyond reasonable doubt. So the option is B is correct. Question number 41. Then question number 42. 42, where a document is executed in several parts like in printing, lithography or photography, video recording, computer resource as an electronic or digital record, the BSA 2023 classify each part as a primary evidence. Then after 43, which section of BSA provide that no court shall require any communication between the minister and the president of India to be produced before it? So the answer is 164, the BSA section 165. BSA section 165, option number B, 43 ka B. Then after question number 44, according to section 46 of the Bharatiya Sakshya Adhiniyam, where character evidence is relevant in civil cases. So the answer is only when related to other relevant facts. 45, as per section 78 clause 2 of the BSA 2023, presumption about the officer signing or certifying a document is, the answer is the officer held the official character claimed when signing or certifying the document. 46, under section 146 of BSA 2023, when the leading question are permissible in the court proceeding. So answer is 46 ka D. Leading question are permitted during cross examination and when matter are introductory, undisputed or sufficiently proved. 47. Which of the following is a characteristic of mediation? Which of the following is a characteristic of mediation? So the answer is it involves a natural third party who facilitates negotiation between the parties. The option is B. 47 ka B. Then after 48, um, a dispute arises between ABC Limited and XYZ Private Limited regarding a contract that both parties had entered into. The agreement include an arbitration clause which state that any dispute shall be referred to arbitration. However, the party failed to agree on the appointment of an arbitrator. Which of the following provision of the Arbitration and Conciliation Act 1996 would be applicable to resolve the issue of appointment of an arbitrator? So the answer is 48 ka A. The court will appoint an arbitrator under section 11 of the party failed to agree on one. 49. Which of the following is not an advantage of using ADR? It always result in a binding decision. Option C. 49 ka C. Then after 50, uh, Kiran and Meera are involved in arbitration where Kiran was awarded Rs 10 lakh as compensation. Meera refused to pay the amount, arguing that the award was not enforceable because of certain procedural irregularities in an arbitration process. Kiran decided to approach the court to enforce the arbitrable award. So the answer is B. Section 36 of the Act allow for the automatic information of an arbitral award unless set aside by the court. 50 ka option B. Then after question number 51, which section discussed with regard to Sapinda relationship under the Hindu Marriage Act 1955? So the answer is section 3 clause F clause 1 and 2 explanation to section 3 G उसका 5 clause 5. So the answer is 51 का D जो डिस्कस करता है सपिंडा रिलेशनशिप अंडर द हिंदू मैरिज एक्ट 1955. 51 का D सेक्शन 3F 1 and 2 explanation to section 3G 5F. Then after 52 को withdrawal कर लिया गया था. 53, Aarti and Rajesh have been married for 5 years. Over time, Aarti has been subjected to continuous cruelty by Rajesh, which has led to emotional and mental distress. Aarti decided to file for divorce on the ground of cruelty under section 13, 1 clause 1A of Hindu Marriage Act 1955. So the answer is B. Aarti can seek divorce on the ground of cruelty as long as she prove mental cruelty or physical cruelty. 54. On matter where Daya Bhaga is silent, what prevail? So the answer is Mithakshara. On matter where Daya Bhaga is silent, Mithakshara is prevail. So question number 55. Nisha and Akash are separate and they both seek custody of their minor child, Arav. Nisa has been the primary caregiver, while Akash claimed that he can provide better financial stability for Arab. They both approached the court under the Guardian and Wards Act 1890. So the option is 55 का सी, द वेलफेयर एंड बेस्ट इंटरेस्ट ऑफ द चाइल्ड। हमेशा कोर्ट ये देखती है बच्चे को देने के लिए किस बच्चे का वेलफेयर कहाँ पे अच्छा होगा, वहां पे बच्चे को देती है। हालांकि 5 साल तक देखा जाता है कि माँ को ही दिया जाता है मेनली। सो 55 का सी। देन आफ्टर 56, ये मैच कॉलम था आपका 56, जिसमें मैच द फॉलोइंग है। स्पोकन स्पोकन वर्ड्स, स्पोकन वर्ड्स सुन्नत ऑल कॉल। उसका दीपिका वर्सेस कैट, दीपिका वर्सेस कैट का हो गया ऑप्शन आपका बी का 4। आर्टिफिकल रिलेशनशिप, साइलेंस, साइलेंस का सुन्नत उल तकरीर। और ये ऑप्शन नंबर ई का हो गया 5, ट्रिपल तलाक, शायरा बानो ट्रिपल तलाक। तो ऑप्शन इज 56 का सी। इसको आप पॉज करके भी 2 मिनट देख सकते हैं, उसको समझ सकते हैं। 56 का आंसर जो है सी है। देन आफ्टर 57 को विड्रॉल कर लिया गया था। 58 पे हम आते हैं। 58, द रेमेडी ऑफ रेस्टिट्यूशन ऑफ कॉन्जुगल राइट इज गिवन इन सेक्शन 9, ऑप्शन नंबर डी 9 ऑफ द हिंदू मैरिज एक्ट 1955। Then come on 59. In which case a prison inmate sent a letter to the Supreme Court describing physical torture which became a pioneer in public interest litigation through the court later abandoned the practice of considering later. 59 का बी, सुनील बत्रा वर्सेस दिल्ली एडमिनिस्ट्रेशन के केस में ये कहा गया था। देन आफ्टर क्वेश्चन नंबर 60, इन द अर्ली 1980 a social activist group discovered severe exploitation of laborer working in stone quarries near Delhi. The worker, including many children, were working in extremely hazardous conditions, living in makeshift shelter, and were effectively trapped in a cycle of debt and forced labor. The condition revealed systematic violation of the fundamental human right. The Supreme Court was approached to look into the dire circumstances of the working person, and one of the following views of the court was sustained in the said case, identified from the following. So the answer is option C. The Supreme Court recognized the right against the forced labor as a fundamental right derived from the right to life and human dignity under Article 21. So the answer is option C, 60 ka. 61. Read the given statement and choose the correct option. In PIL case, the court plays a passive the court play a passive role similar to traditional case. PIL is primarily focused on individual dispute. So the answer is both statement are false. दोनों false है इसमें। 62 पे अगर हम आते हैं, given below are two statement on labeled or assertion and other labeled as reason. इसमें दो दिया गया है। The concept of local standard is lacks in PIL cases. PIL allow any public spirited person to approach the court on behalf of those who cannot represent themselves. So the answer is both A and are true. R is the correct explanation of A. 63. Which of the following best defined delegate legislation? So the option is law made by an administrative authority under power given to them by parliament. Option C. 63 C. 64. In 2020 at Dharoda village, the panchayat election could not happen due to COVID pandemic while the tenure of the panchayat was getting over that year itself. Mr. Harivans represented the people that year at panchayat post dissolution of the panchayat tenure and made a law exercising the delegated power by the Panchayati Raj Act of the state to restrict the economic activities per day to 100 only. In which of the following case this is allowed or restricted? So the answer is MCD versus Birla Cotton Mills. MCD versus Birla Cotton Mills के केस में कहा गया था ऑप्शन ए 64 का। Then comes on 65. Which of the following is not ground for judicial review of administrative action? 65. Option is D only for public opinion. Then 66. What does conflict of interest refer to in professional ethics? What does conflict of interest refer to in professional ethics? So the option is D, a situation where personal interest conflict with professional duties. I would say question number 67. Advocate Mr. X was representing a client Mr. Y in a property dispute case. During the proceeding, advocate Mr. X accepted to bribe from the opposing party to delay the case, causing significant harm to Mr. Y interest. Moreover, Mr. X failed to inform his client about critical hearing date, leading to adverse judgment. So the answer is A. It is violation rules made by the Bar Council of India for the professional ethics. 68. The nature of proceeding in the case of professional misconduct. 68 का आपका ये ओनली 3 होगा, क्वासी क्रिमिनल नेचर। द नेचर ऑफ द प्रोसीडिंग केस ऑफ प्रोफेशनल मिसकंडक्ट क्वासी क्रिमिनल नेचर। 68 का ऑप्शन 3। देन आफ्टर 69, Appropriate procedural safeguard help reduce threat to objectivity and counter any perception of possible bias. Which of the following is a not procedural safeguard? 69 को withdrawal कर लिया गया था इस क्वेश्चन को. Then after 70, as per section 2 clause 84, share means share in the share capital of a company and includes, इसका ऑप्शन जो है वो थ्री ओनली थ्री स्टॉक्स, स्टॉक को सिर्फ इंक्लूड किया गया इसमें इसके डिफिनेशन में. Then after 71, Section 43 of Company Act 2020, 2013 provides for, Section 43 of the Companies Act 2013 provides for option B, kinds of share capital. Then question number 22, a manufacturing company in a city of Surat named as X has been discharging untreated industrial waste into the nearby river, violating the provision of the Environment Protection Act 1986 and the Water Prevention and Control of Pollution Act 1974. This has resulted in severe pollution, making the river water unsafe for drinking and harming aquatic life. Local farmer and resident who rely on the river for irrigation and daily needs have started facing health issue on the crop failure due to contaminated water. Despite multiple complaints to the local pollution control board, no action has been taken against the company. Based on above problem, select the correct answer. So the option is 72 ka A. It is a violation of section 24 of the Water Prevention and Control of Pollution Act 1974. Question number 23. Which of the following act is popularly known as umbrella legislation? So the answer is the Environment Protection Act 1986. Umbrella legislation को कहा जाता है. Option number D. 73 का D. 74. Which of the following is included under section 2 clause 1 clause 2 of Information Technology Act IT Act 2000? Describe intermediary. So the option is B, 1, 3 and 4 means cyber cafe, cyber cap, social media platform, internet service provider. सिर्फ telecom regulatory नहीं है इसमें include. Then after question number 75, Malti, a small business owner, run on an online clothing store. Recently, she noticed that her website had been hacked and her customer personal information, including names, address, and payment detail, was stolen. Shortly after, some of her customer reported unauthorized transaction on their account. Malti wishes to file a complaint against the incident. So the option is A and C both. अगर आपने A भी लगाया तो सही और C भी लगाया तो सही. It is punishable under section 66 of IT Act 2000. Then after, it is punishable under section 66 of the IT Act 2000, and the customer can also claim the compensation under certain circumstances. 76. Which of the following is included under the definition of employer given under the Industrial Relation Code 2023 2020? So the option is D, managing director of ये option number D 1, 2 and 3 means for managing director of the factory को छोड़ के occupier of the factory, manager of the factory and contractor. Then after 77, which of the following legislation has been included under the Social Security Code 2020? So the option is C, 1, 2 and 4. सिर्फ तीन पे द पेमेंट ऑफ बोनस एक्ट 1965 को हटा दिया जाए तो ये तीनों होगा. द मैटरनिटी बेनिफिट एक्ट 1961, पेमेंट ऑफ ग्रेजुटी एक्ट 1972, द एम्प्लॉयमेंट एक्सचेंज कंपल्सरी एंड नोटिफिकेशन ऑफ वैकेंसी एक्ट 1959 को इंक्लूड किया गया सिक्योरिटी आता है सोशल सिक्योरिटी कोड 2020 में. देन आफ्टर 28, dash have not been set up under the provision of Industrial Dispute Act 1947 for education of industrial dispute in an organization. So the answer is environmental tribunals को ऐड नहीं किया गया इसमें. ऑप्शन इज बी 78 का. 79, XYZ Textile Limited, a manufacturing company, recently terminated 4 workers without providing any compensation. The termination was because of the misconduct on the part of the worker. The company issued a so-called notice and the disciplinary inquiry was also conducted against them. On the basis of the recommendation of the committee, the service of these employees were terminated. The workers claimed that retrenchment compensation, which was rejected by the management, agreed by the rejection. The worker had filed a complaint in the labor court under the provision of Industrial Dispute Act 1947. So the answer is option A, the termination does not amount to retrenchment, hence no compensation. फिर 80, क्वेश्चन नंबर 80 पे आ गया. Mr. J, a banker, refused to honor check Mrs. F through she was having sufficient balance. Yes, it does not suffer any loss to Mrs. F. F can file the case under which scenario? अंडर विच सिनेरियो. तो इनका ऑप्शन हो गया पी, इंजुरियन साइन डैमन, इंजुरी हुआ है, इंजुरियन साइन डैमन, इंजुरी विदाउट डैमेज. Then 81, Mr. B told Mr. A to leave the premises in occupation of Mr. A. When Mr. A refused, then Mr. B collected some of his workmen who mustered around Mr. A. They tucking up their sleeves and apron and threatened to break the plaintiff's neck. He did not leave. Under which tortious act Mr. A can file the case? So absolutely assault. ये assault category में आता है. Then after 82, Mr. J, knowing while taking the lift that driver Mr. T was under the influence of alcohol, consequently, car met with the incident and Mr. J got injury and C had failed the case for compensation. Which defense could be claimed by Mr. T? So the option is voluntary non-fit injury. मिस्टर के ऑप्शन इसमें जो हो गया ए 82 का ए 83 मिस्टर के इज ऑनर ऑफ बिल्डिंग कंटेनिंग अ लार्ज नंबर ऑफ रूम्स एंड हैड ड्राइव्ड अ कंसिडरेबल इनकम बाय लेटिंग देम मिस्टर वाई इज ऑनर ऑफ एन adjacent cotton mill which erected after the occupation Mr. K owing to noise and smoke of the mill several rooms remain vacated that result into loss of Mr. K examine relevant tort for the cases 83 सी nonsense ये nonsense category में है 84 there was a collision between two buses, one owned by the government and another was a private bus. When private bus was coming from the wrong side and government bus was coming racely, neither slowing down his bus after seeing the other bus determined the tortious act. 84 का D. Contributory negligence दोनों तरफ से contributory negligence में आएगा. The term income is described in the Income Tax Act 1960. 85 का A. Section 2 clause 24. Mr. X deposit 65,000 in terms of deposit of 5 years with the post office to avail tax deduction under section 80C, assuming Mr. X does not opt for concessional tax regime under section 115B AC of the Income Tax Act 1961. Answer is B. Mr. X is not guilty of either tax evasion, tax avoidance. 87. 87 आपका ये है statement है which statement is true. एंड इसमें बोथ स्टेटमेंट दोनों करेक्ट है एग्रीकल्चर इनकम इज exempt फ्रॉम टैक्स अंडर सेक्शन 1A 10 clause 1 of the income tax in 1961 tax and non-agricultural in case of non-agricultural income exceed basic exemption limit and agriculture income exceed 5,000 is determined by the scheme is partial integration of non-agricultural income with agriculture income दोनों ऑप्शन आपका करेक्ट है 88 पे आते हैं रेंट फ्री अकोमोडेशन प्रोवाइडेड बाय एम्प्लॉयर टू एम्प्लॉई इज इसका आंसर जो है ए है ऑप्शन परक्यूजिस्ट एज पर सेक्शन 17 क्लॉज 2 ऑफ द आईटी एक्ट 89 an agreement not enforceable by law is stated to be void under 89 option D section 2 clause G section 2 clause G an agreement not enforced by law is stated to be void under section 2 clause G 89 option D 90 the concept of invalid guarantee is covered under section the concept of invalid guarantee is covered under section option is B 142 से 144 तक देन 84 पे हम आ गए 90 के बाद फिर ये पेज ऐड हो गया फिर से 90 के बाद फिर ये 91 इसमें केस स्टोरी है इसमें 91 a real estate developer entered into a contract with B the owner of piece of prime land for the purchase of a property the contract stipulated that A would pay 50 lakh in advance and remaining 1 crore with 6 months in return B agreed to transfer the title to the land however after receiving the advance payment B refused to execute the sale deed claiming that she received a better from another buyer demanded the enforcement of the contract and the specific relief act A demanded the enforcement of the contract and the specific relief in 1963 but B denied his claim A has to file a suit in a court of law. 91 option C. A may file suit in the civil court having the power under the Civil Procedure Code 1908. Then after 92, A transfer a piece of land to B on the condition that B shall not transfer the land to anyone else for the next 10 years. In the case B has no right to transfer the land to someone else for the next 10 years. 92 option B. It amount to conditional limitation on transfer of property. फिर 93 पे हम आ गए Mr. Rajesh issued a check of 50,000 to his supplier, Mr. Sharma, for the payment of goods purchased. When Mr. Sharma deposited the check, it was returned by the bank with the remark insufficient fund. So the answer is a complaint. The complaint writing is to be made by Mr. Sharma in the court within 1 month for the dishonor of the check. 94. Section 31 of the Specific Relief Act 1963 is related to 94 का B cancellation of instrument section 38 31 section 31 cancellation of instrument 94 का 95 how the recovery of a specific immovable property can be enforced option D a person entitled to the possession of specific immovable property may recover it in the manner provided by the CPC 1908 then 96 which section of the law contract define a proposal may be क्वेश्चन थोड़ा सा कटा हुआ communication acceptance incomplete against the proposal but not after ये आंसर जो है 96 का A है section 5 क्वेश्चन क्लियर नहीं आ पाया, 97 पे आते हैं। अकॉर्डिंग टू द लैंड एक्विजिशन एक्ट, लैंड एक्विजिशन रिहेबिलिटेशन एंड रीसेटलमेंट एक्ट 2020 2013, गवर्नमेंट कैन एक्वायर लैंड फॉर 97 का डी, 1 2 एंड 3 तीनों ऑप्शन सही है। Strategic purpose, project for families affected by project, for public private partnership project with government ownership of land will remain with the government. 98. Land Acquisition Act 2013 in India has replaced which earlier legislation? So the answer is C. Land Acquisition Act 1894. Land Acquisition Act 1894. Option is 98 ka C. Then after 99, Soham, an independent software developer, created a mobile app called FitLife that provide personalized fitness plan. He registered the app name and logo under trademark law and copyrighted the app source code. However, 6 months after its launch, Soham discovered a competing app called FitLife with a similar logo and feature being marketed by a large tech company. Soham believed that competing app copied element of his source code and intentionally used a confusing similar name and logo to mislead customer. On the basis of ever problem solves the correct option. 99 का option A, yes, if he can prove that the names are confusingly similar. ये आपको copyright से related question है, patent से related question, IPR. Then after last question, question number 100, what is the duration of copyright protection for literally work in India? ये copyright का question है जिसका आंसर C है, lifetime of the author plus 60 year. Thank you.